Hello, everybody, and welcome to this workshop. Apologies for a few minutes of delay, but we are now ready to start. Please, Alban.
Okay. I hope there will be no problem with the coverage I have with my internet, because from time to time it just goes up and down. But so, ladies and gentlemen, I'm Alban Magia. I'm the president of SMEunited, and on behalf of Small Business Standards and SMEunited, I am pleased to welcome you today to this workshop on EU-UK Trade Agreement, a practical guide for SMEs. I will say a few words about the two organizers. Small Business Standards, SBS, is the European association representing and supporting SMEs in the standardization process, both at European and international level. SMEunited is the association of crafts and SMEs in Europe. We are a European social partner and speak with EU institutions on behalf of those 25 million SMEs and their 100 million employees. And then I go to the topic of the day, the decision of the UK to leave the EU, and the ratification of the Trade and Cooperation Agreement last week initiates a new era for the EU-UK relationship. It strongly impacts millions of SMEs operating on both sides of the channel. Naturally, SMEs are adapting their way of doing business to comply with the new rules and procedures and standards in this post-Brexit area. SMEunited and SBS support SMEs in this transition process that has generated uncertainty over the past month. So new aspects are emerging related to travel and border controls, trading goods, and much more. In this regard, clarity on applicable rules and access to information for SMEs are keys. Moreover, the significant change in EU-UK relation coincides with an extremely challenging historical moment due to the consequences of the COVID-19 pandemic. So today we are glad to have with us distinguished speakers who will provide us with, first, a general overview of the EU-UK trade agreement, second, information on the new UK CA mark and conformity assessment, and third, information on standards in the UK. The webinar today is timely. SMEs already face concrete difficulties. First, the smart border system generates a duplication of administrative procedures at the European and British borders. Second, SMEs have to devote more time to administrative procedures and invest in training to develop the necessary skills. And third, unclarity exists, I would even say prevails, about application of rules of origin, standards, and so on. Therefore, SMEunited and SBS welcome that a new EU-UK trade partnership was concluded and the no-deal scenario was avoided. The agreement, which allows for trade free of quotas and custom duties, has been implemented as from January 1st and got formally approved by the European Parliament and Council last week. So with regards to the EU-UK Trade and Cooperation Agreement, we would like to convey the 5 following messages. First, we welcome that an SMEs chapter has been included in this agreement. It is essential that the agreement ensures transparent and easily accessible information on tariffs, and the rules of the origin will be provided. An SME contact point or information portal should support SMEs. Second point, additionally, we insist on a clear framework that safeguards trade in goods and services under conditions of fair competition. SMEs need a level playing field, ensuring a common standard strategy, the minimization of customs and technical barriers, and a constant cooperation between EU and UK authorities. Third, we should monitor and implement what has been agreed. This will be crucial in the upcoming months and years for a smooth continuation of trade. Fourth point, we invite the EU-UK institution to look at other areas of possible cooperation, such as the trade in services. Fifth point and final one, cooperation in the area of standards is essential. Standards and conformity assessment play an essential role in trade. Diverging standards and conformity assessment procedures can have negative effects on trade. They can create technical obstacles or impose duplicative testing and certification. This always has disproportionate effects on SMEs. To conclude, I would like to emphasize that the EU-UK trade relationship should be an opportunity to rethink the mutual benefits deriving from cooperation. It should set the stage for a supportive economic environment where SMEs are enabled to continue offering their goods and services in a clear legal framework. I wish you a fruitful exchange this afternoon and will now give the floor to Maitane Olebaria, the Director of SBS, Small Business Standards, who will be the person moderating the event today. The floor is yours, Maitane, and thank you for inviting me.
Thank you very much, Alban, for your kind introduction to this online workshop, and good afternoon as well to all the participants that are joining us online today from my side as well. As Alban said, we have been joined today by three very knowledgeable speakers that will help us to better understand the implications of the new EU-UK trade and cooperation agreement for all those European companies that are wishing to do or continue to do businesses in the UK as from January this year. So as we said, the focus of SBS and SMEunited is of course SMEs. So we hope this workshop will provide useful information for them. But before I give the floor to our first speaker, let me first just share with you a couple of practical points. First of all, we foresee some time for questions and answers at the end of the workshop. You can write your questions at any time in the Q&A panel. Try to keep your questions as short as possible as well, please. And as I said, we are going to take questions mainly at the end of this online meeting. But unfortunately, regarding our first speaker, Ignacio Iruarrizaga, he will have to leave us before the end of the workshop. So for questions for him will be just addressed immediately after his presentation. So we will have time after his presentation to ask some of the questions. We have also received a couple of questions ahead of the meeting. We will also address those during the Q&A at the end of the workshop, if not already addressed by our speakers in their presentations. And finally, I just wanted to say regarding practical information that the workshop will be recorded, and the recording and the presentations will be made available after the workshop in the SBS website. So you will receive an email at the end of the week with the link you can use to access them. And let me now move to our first speaker, Ignacio Iruarrizaga. It's for me a pleasure to introduce a fellow Basque citizen. Ignacio has been working nearly 30 years in the European Commission. He's currently the head of unit for trade relations with Europe and Eastern partners, which is the unit in charge of negotiating and implementing the trade aspects of agreements in that geographical area. Within the European Commission DG for trade. And of course, this also includes the EU-UK Trade and Cooperation Agreement that will be the topic he will be talking to us about in his presentation. So please, Ignacio, the floor is yours.
Many thanks, Maitane, and good afternoon to all of you. And many thanks to the organization for offering us the opportunity of presenting briefly the agreement and having the opportunity also of engaging with you in getting your comments and trying to address the questions you may have. I was heavily involved. I will be in charge of the implementation of the trade aspects of the agreement with the UK, and I was also heavily involved in the process of negotiating the agreement, which was an interesting experience. So let me try to present it briefly. I understand that I have half an hour in total for the presentation and questions, and I will try to deliver on that time constraint and leaving some time for questions. And I will also try to have some comments on the very useful points made by Alban at the beginning of this afternoon session. So I will start then with the presentation. This was an agreement like no other, and I will go back to this slide. So no, let me move it myself. So it was the first time in which we have been negotiating an agreement in which we were dealing with the management of divergence rather than trying to converge. I mean, in normally trade agreements, we make an effort to to different degrees trying to converge with the third party. In the case of the UK, we were starting with full convergence, and we were trying to manage the divergence in an intelligent fashion, while trying to address the UK constraint, which was that they wanted to have a relationship based on an FTA. And they did not want to engage into a process of regulatory approximation, and indeed they did not want to maintain our rules, and we had to respect the position of the UK as a sovereign third country. And with those constraints, we were trying to build an agreement that we think that delivers on that as a good agreement. Now, what does it cover? I'm trying to move. So I'm trying to move in the slides. I'm not good at this. Yeah, the partnership agreement is very comprehensive. So we have a classical. If you look at the slide, we have an agreement that delivers on what is a classical FTA, which is the first box where you see free, fair, and sustainable trade. We have trading goods, trading services, investment, public procurement, and then we have a very robust chapter on level playing field that goes beyond what we classically have in an FTA. In addition to that, we have in the economic area of the TCA other areas that typically are not covered by an FTA. Transport, we have an agreement on. The agreement covers road transport, air transport, energy and climate, fisheries and national resources, social security coordination, and access to union programs. So that is part of the economic agreement, which is classically not included in an FTA. In addition, we have other aspects of the agreement in non-economic, non-trade areas, law enforcement and judicial cooperation and criminal matters, notably. The entire agreement is subject to a common governance framework. And the common governance framework includes two key features. One is that we have a common set of institutions. We have a partnership council, and then we have a set of committees to ensure a smooth implementation of the different areas of the agreement. In the area of trade, we have a committee, which is a trade partnership committee, to which there are several specialist committees reporting. There is a specialist committee dealing with SPS, and a specialist committee dealing with technical barriers to trade, another one with trading services, with public procurement, etc. And these specialist committees report to the Trade Partnership Committee, who in turn reports to the Partnership Council, who is the one that can take decisions to modify aspects of the agreement. We have a common dispute settlement mechanism cutting across the entire agreement, with some specificities in some elements of level playing field. And one element which is important, we have the ability to take measures as a result of adjudication. After there is an adjudication by a panel, we can take measures that go beyond the area where the dispute was taking place. So if there is a dispute in trading services, we may take measures to compensate in trading goods and vice versa, or in transport, etc. So there is the ability to take measures in case of non-compliance by the other party that go beyond the area where the non-compliance took place. Outside of the agreement, and you see on the right-hand side of the slide, we have decisions that we wanted to remain autonomous. And those decisions include equivalency in financial services, the adequacy decision on data protection, and you may have seen the draft decision that the Commission has published. It's a draft still, or decisions on, for instance, listing of UK for SPS purposes. So a very comprehensive agreement going beyond classical trade, with a very robust level playing field element, and with a common regulatory framework, and leaving aside areas that we consider that should remain autonomous decisions. Now, as I said, we were working under the constraints. If you want imposed by the UK, having an FTA without regulatory convergence, and the objective, that created some limitations as to what could be achieved. But we were aiming at obtaining, and we think that we obtain, high quality market access, which again cannot be compared to what you have in the internal market, but very high quality market access when you compare it to any FTA. While, and that was the objective which was attained, while not compromising the autonomy and integrity of the internal market, and securing a clear and enforceable level playing field. The second bullet is very important. We could not, and we did not an intention, and we did not compromise the autonomy and integrity of the internal market. We respected the decision by the UK not, to leave the union indeed, and to have its own regulatory framework that may evolve outside the regulatory framework of the union. But at the same time, we wanted to ensure that we preserve our ability to autonomously continue regulating the internal market, and that the internal market was not on a piecemeal basis open to access on internal market basis by a third country. And then we had to secure a clear and enforceable level playing field. That was part of our mandate, and we achieved that. Now, let me start with maybe the quality internal market that was obtained. So we have an agreement with zero tariffs and zero duties. We have zero tariffs and zero duties for zero quotas and zero tariffs for all products. I mean, that is the first agreement in which we achieved that. We have obtained disciplines that go beyond WTO disciplines in trading goods. Elements like prohibition of import and export monopolies, clear disciplines on import and export licensing. We have an unprecedented agreement on government procurement. This is the most ambitious agreement we have concluded with any third party ever in the area of government procurement, that includes something that should be important for SMEs, which is that any subsidiary of a European company established in the UK should enjoy full national treatment in the UK when it comes to public procurement, even below public procurement thresholds. So there are thresholds for public procurement in the GPA, in the government procurement agreement of the WTO. And below those thresholds, normally the parties can discriminate. What we have obtained in the TCA is that below those thresholds, however small a particular public contract opportunity might be, if you have a establishment in the UK, that establishment cannot be discriminated compared to UK establishments. We have a commitments in the services trade that go beyond what we have obtained in what was our reference agreement until then, which is EU-Japan FTA. We have a state-of-the-art commitments on intellectual property rights. We have an SME chapter, as Alban indicated at the beginning of his presentation. We have even included in the agreement, a provision on the cooperation and the return of cultural goods, as what requested by some of our member states. So very high quality market access that compares as an excellent product with any FTA. But of course, that excellent FTA is not the same as membership of the Union. So you have to expect that when trading with the UK, you are not going to have the same situation as before. Necessarily, there are border controls because the UK is outside of the Union and is developing its own regulatory framework. So at the border, we have to control compliance with sanitary and phytosanitary standards. We have to control compliance with technical standards for industrial goods. We have to verify indeed compliance with rules of origin, which have to be met, and you have to be able to prove that you are meeting those rules of origin. And those are the consequences of the departure from the internal market and the moving from that into an FTA type of agreement. That you don't have what we call frictionless trade, as we know in the internal market. Little by little, rules for industrial products may differ. Rules for sanitary and phytosanitary products, agricultural products may differ as well, and I will talk about that in a minute. When you export to the UK, you will have to certify products. When you have to certify products, and I will go back to that in a minute. In the Union, in the UK for exports to the UK, the same way as UK exporters will have to certify in the Union for exports to the Union, and more importantly, we'll have to certify against the rules of the other party, because the rules of the other party may evolve. In the area of financial services, for instance, there will be no passporting rights. So if you establish yourself in one jurisdiction, doesn't mean that you can operate in other areas without asking for a license, and so on and so forth. So the relationship is different, and we have to accept that fact. Now, we had, as I said, one of the objectives was to obtain high quality market access without compromising the autonomy of the internal market, and then having good level playing field. We have excellent disciplines on state aid control and competition and on the state-owned enterprises. We have provisions on non-regression in labor, social, environment, climate, and taxation levels of protection, which in the area of labor, social, environmental, and climate basically means that the rules at the end of the standards at the end of the transitional period the parties cannot go down on the standards at the end of the transitional period, and that ensures that we lock each other. I mean, we can change our regulations, but we should not be going, worsening our standards. That is a very important element. We have rules on trade and sustainable development, similar to what we have in other agreements, and we have very robust enforcement tools. We have domestic enforcement, dispute settlement, and we also have the availability of unilateral tools if need be. Finally, and this is very important, we don't have dynamic alignment of the UK with the Union or the Union with the UK, but we have the possibility to address divergence in the rules over time. So if there are significant divergence in the rules in a particular area over time, and that divergence is having a significant impact on trade, we can address that divergence by taking unilateral action. And that we think it is very important in terms of making sure that the TCA is going to be relevant in terms of level playing field in the future. Now let me move into developing a bit more on technical barriers to trade, which I think is of key importance for you. We did not seek in the technical barriers to trade to keep the UK locked to our rules, because the UK made very clear from the outset that that was not possible for them to accept. So we focus instead in ensuring that there are mechanisms in the agreement that will facilitate continuous convergence of rules, and we focus on ensuring that we minimize certification costs. How do we work on looking at future compatibility? That the regulatory framework in the future on technical regulations for industrial products are convergent in the future. We thought that the key for that was to ensure that we have the same understanding of what is an international standard. We both have an obligation by virtue of the WTO technical barriers to trade agreement to give a particular treatment to international standards. So when you enact legislation, technical legislation, you have to look at the available international standards, and if they are available, in principle, follow them for your own technical regulations. What the WTO TBT agreement does not do is to define what an international standard is. The TCA fills that gap. So the TCA contains a very clear definition of what is an international standard that corresponds to what has been the common understanding of the Union members until and remains the common understanding of the Union members, and that the UK has been prepared to sign to in the TCA. So we have a definition of international standards which is clear, which indicates which are the international institutions that can issue international standards within the meaning of the WTO TBT agreement, and then indicates that other international bodies may issue international standards provided that some conditions are met, and those conditions are clearly spelled out. So it is the first time in which we have that clarity, clear definition in an international agreement, other than in Mercosur, that has not yet entered into force. And we have that definition also in some non-preferential agreements. But in terms of FTAs, we have it in Mercosur and now in the TCA. International standards will evolve over time, and so will evolve our technical regulations in different areas and the UK technical regulations. But if both continue working in the same international fora, let's say to simplify, in the ISO, ISE framework, to develop international standards, and once those international standards have been developed, we give them preference when developing technical regulations in our own regulatory frameworks, the Union and the UK. We would have made a major step forward in ensuring that our future technical regulations will remain largely convergent. So that was, we think, a major achievement of the TCA. The second very important feature of the technical barriers to trade agreement of the TCA is that we wanted to ensure that the certification-friendly framework that prevails in the Union will continue for the future trade between the Union and the UK. And by that, we mean the extensive use of self-declaration of conformity for industrial products. So the TBT chapter of the TCA contains provisions that indicate that the two parties will continue applying self-declaration of conformity in the areas where they applied them at the time of the entry into force of the agreement. There is the possibility to change that for products if there is a well-justified reason in the future, because of course we don't know what the future may bring to us. And it may well be that for a particular area, we want to introduce third-party certification in the future because we consider that a particular product has evolved or a family of products is evolving in a way that requires third-party certification. But we start the relationship with preserving that sort of business-friendly approach that we apply in the Union, which is to be relatively very open to self-declaration of conformity in areas of low risk, and where, on that the Union is an example internationally, and we have ensured that that will continue in the trade between the two parties. What we did not agree to is to a mutual recognition agreement between the parties, i.e. we did not foresee that exports from the UK to the Union could be certified in the UK. We wanted to ensure that goods are certified against the technical regulations of the other party, and we wanted to ensure that goods that are exported to the Union in areas of relatively high risk, which are the areas where third-party certification is required, are certified in the Union and not in the UK. Other than that, the technical barriers to trade chapter contains several regulatory chapters on cars, which is a relatively classic agreement, classical feature of our FTAs. A new chapter, a chapter on chemicals, which is an annex on chemicals, which is a new feature, which puts the emphasis on cooperation largely, on medical products, where we have an agreement on the recognition of good manufacturing practice certificates. We have an agreement on wine, which is very similar to what we have in other FTAs, and we have an agreement on organics, which is a relatively new feature and which is very similar to what we have in the agreement with Chile, and that will need to be reviewed. The elements of equivalency in that agreement will have to be reviewed in 2023 to reflect the entry into force of the new regulation of the Union in that area in 2022. Now, a word on implementation. So now we have to put the emphasis on implementation. That is the point 3 of the 5 elements that Alban was stressing in his initial introduction. That is where we want to put our money now, on implementation. I mean, the agreement is a complex agreement, it's a very good agreement for an FTA, and we have to put our effort in ensuring implementation. Complaints by the industry should be channeled through the so-called single entry point that we have developed in DigiTrade. Any complaints related to trade or level playing field should be introduced through that mechanism. We need your input. I mean, we need the input of the industry, individual companies, and input that you can either send directly or through your associations, because you are our eyes on the ground. I mean, we will not identify some of the wrong implementation of the TCA if that was to happen, unless you tell us. So please be mindful every time you encounter difficulties that relate to what you consider that relate to the wrong implementation of the TCA, to bring that to our attention, and try to distinguish on that issues that you encounter that are simply the result of the new relationship and the wrong application of the TCA. So if you have to comply with the rules of origin, that is a feature on which one can be unhappy about, but it is perfectly compatible with the TCA. Now, if you consider that the proof that you are being requested to submit to establish that you met the rules of origin goes beyond what the TCA caters for, then please contact us through the single entry point. And the last slide contains some useful link in that regard. Now, a couple of comments to conclude on what Alban said. Future cooperation, have more cooperation in new areas with the UK. We want to be put a note of caution on that. I think the emphasis is we are going to put our emphasis on implementation of the TCA, not on developing new areas of cooperation right now. I mean, we are open to cooperation, of course, but that is not where we want to put the emphasis. Cooperation in the area of standards is essential, Alban said on the fifth point. We think that what we have in terms of the definition of international standards that we have in the agreement should help us in being convergent, and that is where we want to put the emphasis on enforcement of that provision rather than on cooperation. As you know, it is not inconceivable that the UK standardizer gets into some form of close cooperation relationship with Sensenelec, and we follow that closely. But that is outside, direct government intervention, if you wish. But we think that in the standards area, the emphasis on our side is going to be on enforcing the provisions that we have. And with that, Maitane, I will be more happy to engage in questions and answers.
Thank you very much, Ignacio, for this comprehensive overview. We have already a couple of questions. The first one is from Thomas Palgrim, and he's asking a bit more about services. He's asking what is included in trade in services, and because apparently he had some problems to advise companies regarding what is included in the deal and how to deal with VAT issues.
Okay, and then Barbara, shall I try to answer one by one, or try to
that one? I have to read the second one. It's rather long.
I can try on services. I mean, what the agreement contains on services is what classically we have in an agreement on trading in trading services, and in an FTA on trading services, if you wish, which is that we have provisions where each party has to list the areas where it's not offering full national treatment to the service providers of the other party, and where it has quantitative restrictions to the provision of services. So that is what we typically have in an FTA, and that is what and what you have in the WTO services agreement in the GATS, and that is what we have in the agreement with the UK. In terms of the reservations, is where I said that we have gone beyond. We have commitments from the UK that go beyond what we obtained in our reference agreement, which was the FTA between the Union and Japan. So we have, if you want, less restrictions listed by the UK in the trading services chapter than we have, for instance, in the agreement with, or notably in the agreement with Japan. But what we cover is that, quantitative restrictions, limiting the areas in which you can apply quantitative restrictions, and having clarity in the areas where a party reserves the right to discriminate when it comes to the provision of a service. In addition to that, we have several regulatory annexes on trading in trading services, in financial services, in telecommunications, on digital trade, on the Mode 4, or on maritime transport.
Okay, so the second question indeed has to do with construction, and has to do also what you were mentioning before regarding also testing certificates, and basically it has to do with testing. It's mentioning that for some tests will not be valid in the UK from 2022, some test results. So SMEs will have to pay to do the tests again, which of course is a considerable cost for SMEs. But they are also referring to the fact that in addition, in the case of some products, there are not adequate test facilities in the UK, it seems, because they were all spread over the EU. So I don't know if you have any comments on this. Of course, I would also like to know, you were mentioning that mutual recognition regarding conformity assessment is not a part of the deal, but I don't know if there are any plans maybe to work in the future in this area.
Okay, so indeed we will have to certify products in areas where third-party certification is required, and that is very important. Because there are many areas where third-party certification is not required by our legislation and the UK's legislation, and that is captured in the agreement. In areas where no third-party certification is required, you continue operating as before, i.e., the producer can self-certify the product. When third-party certification is required, and those areas are constrained by the agreement itself, when third-party certification is required, you have to indeed certify. When you export to the UK, you have to certify indeed the products in the UK. We have no plans to have a mutual recognition agreement. That was a conscious choice in the negotiation. I think the UK has a large certifying industry that has inter alia grown inter alia thanks to its membership of the union. And we did not want that situation to continue after the departure of the UK from the union. So we wanted to make sure that when the UK was exporting to the union, they would certify in the union. Of course, the same applies the other way around, and we will have to ourselves also certify in the UK. If you think that there are specific areas where that there are bottlenecks in certifying in the UK, so that is useful information that we will be more than happy to receive. But we have no plans to look at a possible agreement in MRA in the future. Yeah, I think that's the answer.
I think Sam McGeever, our second speaker, I don't know if you want to comment on this, because maybe you want to say something now or during your presentation.
Thanks, Maitani. I mean, perhaps it would be good, maybe we come to this question after my presentation, because at least part of that is going to be covering how to certify products for the UK market. Ignacio is right, that's what businesses will need to do, but we'll explain a little bit how to go about doing that, which might help answer Barbara's question.
Yeah.
Okay, thank you about that. I just have actually a question that we received before the workshop was organized, and I don't know, Ignacio, if you can comment on this question, and then we can move to the next speaker.
And the question was?
It had to do with data protection. So the question that we received was, what effect does the trade deal have on data protection, and if it's still possible to transfer data to and from Europe? I understand the Commission is working on this issue.
Yeah. Yes, indeed. I mean, as I said in one of the initial slides, I think the question of what we call adequacy of the UK to receive data transfers is the result. I mean, will be handled by an autonomous decision of the union, and there are two decisions. One on for, if I can simplify, for private use and for official use, and we have made a a proposal to the council. We have consulted with the data protection supervisor in the union. We are taking into account their comments, and we anticipate that relatively soon those decisions will be adopted.
Okay, thank you. I see someone raised a hand, but I will leave that because we need to move on, and also Ignacio has to go to another meeting, actually.
I could still stay 5 minutes more. I have no problem, but if you want to move on, move on.
Yes, I think we should move on. I mean, in any case, there are a couple of your colleagues that will be present as well until the end of the meeting. So so the person that raised the hand will have the opportunity to ask the question a bit later on. Thank you once more for the presentation. It was very much appreciated, and yeah.
Thanks to all of you, and my apologies. I would have loved staying for the other two presentations. Take care.
Okay, thank
Bye.
you. Bye. So we are now moving to our next speaker. So Sam McGeever, who is the Deputy Director for Goods Regulation at the Department of Business in the UK. And I think he's very well placed to give us a few more details also about the question that was just asked before, and also what are the rules that are applicable now to products placed in the EU market. His team worked on the technical barriers to trade chapter of the EU-UK agreement last year. And he's also now working on implementing the UK's new domestic regime, as well as on free trade agreements negotiations with other trading partners. So please, Sam, the floor is yours.
Thank you very much, and good afternoon, everybody. I'm also joined today by my colleagues Charlotte Dicken and Erin Fair, who work with us on business readiness. I know Ignacio has had to leave us, but it was great to see him and some of the team that we worked with on negotiating the TCA. I think I would agree with the description that Ignacio gave, that the negotiations were interesting, but the outcome was a good one. That was a really helpful, I think, overview of the Trading Cooperation Agreement overall. And what we are going to do now is zoom in a little bit to the detail of what it actually means for doing business on the ground in the UK. We're going to spend probably about 10 or 15 minutes talking about how to place your manufactured goods on the market in the UK. I'm going to give a very basic introduction to some of the key concepts, because of course the time won't allow to cover absolutely everything, and we can't advise on every single individual circumstance, but what we can hopefully do is give you some high-level pointers that will help explain the basics, and also we can share these slides so that afterwards you'll be able to read the detail yourselves, and also follow the links to some of the guidance that we have got online that talk you through it in more detail. So the first question that you need to ask yourself is, and I am just going to move on to the next slide. There we go. The first question that you need to ask yourself is, which rules apply? You are all already familiar with the EU framework, so you will know that manufactured goods, industrial products, are divided into different regimes. Firstly, we have the new approach, which are goods that can be carry a CE marking in the EU, and things like toys, machinery, some pressure vessels, and so on. Secondly, the old approach, goods are covered by standalone regulatory frameworks for things like vehicles or medicinal products, and they tend to be covered in FTAs by some of the annexes that Ignacio mentioned. Thirdly, we have non-harmonized goods, where there was previously mutual recognition between the UK and the EU, and there still is mutual recognition within the single market, but between the UK and the EU, there is no longer mutual recognition. And finally, there are some other goods, there are some other products where there are special rules. You can see there a list of some of them. I won't cover them one by one. I think the key message is that once you've worked out which rules apply to your product, you should check the specific rules as well as relying on these on the general pointers. Our focus today is definitely going to be on the new approach. So that first category of goods where you can use the CE mark when you are selling products in the EU. Once you know which rules apply to your product, there are several steps that you need to take to work out what you need to do to put it on the market in the UK. And some of them are listed here. And this is mostly to remind you that although we're going to talk a lot about the UK CA mark this afternoon and how to use it, how to get a UK CA mark and how to apply it to your product, there might also be some other steps that you need to take. You might, for example, need a new authorised representative, or other businesses in your supply chain who have previously been distributors might become importers. You might also need to change the label on your product and include a new address. So it's not just the UK CA marking that you need for placing products on the market in Great Britain, but we will go through each of these steps one by one. So what do you need to do to put a new approach good on the market in Great Britain now that the transition period has ended? So the first thing that you need to know is that individual goods that were already on the market before the end of the transition period, which have a CE mark, are still valid for the market in Great Britain, and they can continue to circulate until they reach their end user. That's because of the withdrawal agreement. Now, most of those goods may have already moved on to their end user, but it's important that you know that goods that were already on the shelf at midnight on the 31st of December didn't immediately become illegal. Second thing to know is that for the rest of this year, so for the rest of 2021, you can still keep on using the CE mark for most products. And that's an additional transitional measure that we've introduced in the UK on the way to making the UK CE mark widespread and compulsory for all products. Thirdly, there are some other transitional measures in place. For example, until the end of next year, so until the end of 2022, in most cases where you need to have a UK CA mark, you'll be able to put it on a label or on a document that accompanies the product rather than displaying it on the product itself. And I will show you in just a moment a timeline of how all of that will work. But I think the overall message that it's important for everybody to take away is that these are all transitional steps, intermediate milestones on the way towards needing a UK CA mark to place your manufactured good on the market in Great Britain. So here it is. This is the UK CA marking. There you can see it on the right next to the CE marking that you will be familiar with. It's the new conformity assessment marking for placing goods on the market in Great Britain. So goods that are being put on the market in England, Wales or Scotland. It covers most of the goods where you would have previously used a CE marking. And we would encourage you here in the UK to start using it now if you can. It already was available from the 1st of January this year, and there is no reason why you can't start using it already, even if the transitional measures are in place for a little bit longer. The essential requirements in legislation and the designated standards that can be used to demonstrate conformity for UKCA are the same right now as for the CE marking, and that will remain the case unless either party decides to change its rules in future. If you use self-declaration to get your CE marking, so if you've got one of those lower risk products that Ignacio talked about, where self-declaration is the way that you apply the CE marking to your product, you could also use self-declaration for the UK CA mark, so you can get started already. If though you have got a product type that needs third-party conformity assessment, you will need to take one further step, which is working out whether you get your third-party conformity assessment from a body based in the UK or one based in the EU, and we will talk you through that in just a moment. And finally, while you can see both of those marks on screen, let me answer one question that we get very often, which is whether or not it's possible to use both marks on the same product. And the answer to that is yes, you can have both the CE mark and the UK CA mark on the same product, providing that your product meets the requirements to carry both marks. And indeed, of course, you can include other marks too if you need those to sell your product in other markets. So I've already mentioned some of the transitional measures, but let me just show you this timeline which summarizes those. And as you can see on the left-hand side, the UK CA mark is already part of the law in the UK, and you can use it for putting goods on the market in Great Britain. It will become mandatory for most products from the 1st of January next year. That's 2022, and applying the UK CA mark to the product itself, directly to the product, rather than to a label or an accompanying document, will become mandatory from the 1st of January 2023. The only case where you must already use the UK CA mark is where you have a product that has been third-party conformity assessed by a body here in the UK. But if you should be using it already, then you will likely know that already. But for anybody that is either self-declaring or using a notified body in the EU for conformity assessment currently, these are the timelines that you need to be working towards. So you will, as I've said, already be able to use the UK CA mark if you self-declare, so you know what to do in that case. But there are some products, as Ignacio mentioned, that do require third-party conformity assessment, and that's the case typically when the risk level is higher and there's a greater potential threat to consumers or the environment. And for those products where the testing is mandatory, and just to clarify, we really are talking about products where the legislation requires the testing, not just where manufacturers choose to do some testing externally before self-declaring. We are talking here about mandatory self-declaration, mandatory third-party conformity assessment. In those situations, because there's not a mutual recognition agreement between the EU and the UK, conformity assessment bodies in the UK have taken on a new role. Since the 1st of January 2021, UK notified bodies that you would have found on the Commission's NANDO list are now called approved bodies, and they do a different set of things. Firstly, they can test your product for the UK CA mark to allow you to sell it in the UK, but they cannot test for the CE mark, and so a UK-based body will not be able to test your product for the EU market for the reasons that Ignacio set out, or a GB-based body rather. They are, though, still all notified bodies for the purposes of the Northern Ireland market, where Northern Ireland follows EU rules, and will come on to the special circumstances that apply in Northern Ireland in just a moment. So just to recap, since the start of this year, the notified bodies in the UK that you would have found on NANDO, there's about 70 or 80 of them covering a whole variety of sectors, are now also approved bodies in UK law for the same product types. They can't test for the EU market, but nor can EU notified bodies test for the GB market. So what you will need to do, and what your members will need to do, is make sure that they have separate certificates for the GB and EU markets, the first from an approved body and the second from a notified body. This, I think, goes a little bit to answering the question that came up earlier. Our strong message to businesses is to encourage them to speak to conformity assessment bodies as soon as possible, where they haven't already, to understand what options they have to arrange for the transfer of certificates between their approved body and their notified body, depending on which direction is needed. But as I've said, where the legislation allows for self-declaration, that can continue to happen. So the changes on this slide and the previous one are only relevant where there is mandatory third-party conformity assessment. I am not going to dwell on this slide for very long because there's much more detailed guidance available online. But the thing that I wanted to highlight here is what I mentioned at the start, which is that where you previously had people in your supply chain who were acting as distributors, under EU law. They may well have become importers if they're bringing products into the UK, or they may well become importers for the purposes of the EU market if they are exporting products from here in the UK into the EU. And as I think you will all know, the responsibilities for importers are greater for distributors. I won't recap all of that, as I said, but there is a little bit more detail on the slide, and you can also find out more in our guidance. As promised, I wanted to also talk you through the rules that apply in Northern Ireland before I wrap up, because until now, everything that I have said has been only applicable to the Great Britain market. I'm only going to talk about regulation. I'm not going to talk about the special customs arrangements or anything like that that apply in Northern Ireland. As a lot of you will know, because of the Northern Ireland Protocol, goods that are placed on the market in Northern Ireland will need to meet EU regulatory requirements, and that is true for as long as the protocol to the withdrawal agreement remains in force. And so because Northern Ireland continues to apply EU rules, the CE marking continues to be the marking that you will see rather than the UKCA mark. In concrete terms, for businesses that want to sell products to Northern Ireland, that means that you will keep on using the CE marking if you self-declare your conformity assessment, or if you use an EU notified body to carry out your mandatory conformity assessment. However, and this is the but, products which have had mandatory conformity assessment done because it's required by law, but where that has happened in the UK, those products can't be placed on the market in the 27 EU member states, and instead, to be placed on the market in Northern Ireland and Northern Ireland only, they need a CE UK NI mark. So just to clarify, the UK NI mark is a new conformity assessment mark that shows a product can only be placed on the market in Northern Ireland, and it goes alongside the CE marking, which is required by EU rules. So although you can see it on the corner of my screen here, this slide, a UK NI mark on its own, that is something that you will never actually see on the market if people are following the rules, because the UK NI mark accompanies the CE mark to show that a product is being tested by a UK body for the market in Northern Ireland, but not for the market in the EU. There are also rules for goods that are already on the market in Northern Ireland, but then move from Northern Ireland into Great Britain. Because Northern Ireland is part of the UK, there is a separate regime for those goods, which means that there will be unfettered access to the market in the rest of the UK, so to the Great Britain market of England, Scotland and Wales, for goods that are already in Northern Ireland. So any of those qualifying Northern Ireland goods, whether they have a CE mark on its own or a CE mark and a UK NI mark, can be placed on the market in Great Britain under our commitment to unfettered access, even where that would not normally be allowed. I know from the list of attendees that many of you are based in the EU rather than in Northern Ireland, so I don't think this will affect you directly. So I'm not going to go into it in any more detail, but I'm very happy to answer any questions. The final thing to say before I pause and take questions is that some of those obligations on importers and distributors in the supply chain that I mentioned a few slides back will also apply to businesses that have Northern Ireland in the supply chain. So once again, if that is your case, I would suggest you look at the guidance. I will just move us forward to this slide here, which I will, which is in the pack, which we'll share with you so you can get some links to the guidance. Before I wrap up and take questions, I just wanted to kind of summarize a couple of points really quickly. The first is, as I said right at the top, there is lots of guidance on gov.uk that goes into all of this in a lot more detail than I've been able to cover here this afternoon. And a couple of the key messages that I think you should take away. Firstly, the essential requirements for UKCA are the same as for CE at the moment. Secondly, UKCA is already available. So if you self-declare or are using a cab in the UK or have already managed to transfer your certification, you can start putting it on your product right now. If you aren't using it already, but you know that you will need to, there is still time, and there are some transitional measures in place. For the rest of this year, the CE marking is still valid for most products, longer in some cases. And where you need time to change your packaging and so on, the UKCA mark can be displayed on a label or an accompanying document if you have not yet had time to change the product itself. And that transitional measure is true until the end of 2022. I'm going to stop there because I've already spoken for slightly longer than I expected to. And I hope we can take the slides down so you can all see my face and I can see others. And then I'll be very, very happy to take any questions.
Thank you very much, Sam. I think it was a lot of information and quite useful as well. If you don't mind, what we are going to do is to move to the next speaker, because we had questions before because Ignacio had to leave. But if you don't mind, we will move to the next speaker and then take all questions. I see also like that people have time to type their questions, because I don't see any so far. But we will then move to our next speaker, and then in the meantime, people can write their questions and we can address them all at the end. So we are now going to move then to our next speaker, Richard Collin. I have the pleasure of knowing Richard for many years now. He has over 30 years experience in standardization and quality infrastructure, including working in the UK government and the European Commission. And he's now responsible for standard policy issues within BSI, the British Standards Institution, that is the UK's national standards body. So please, Richard, the floor is all yours.
Thanks, Matani. Thank you very much. Yes, I have worked in this sort of area for 30 years, but we haven't known each other for 30 years, so unfortunately, only about half of that anyway.
Yes.
Great. Good afternoon, everybody. Yes, Richard Collin from the British Standards Institution. We'll talk to you a relatively short time about the standards in the UK after EU exit. And of course, there's been much talk about TCA, of course, about UK regulations, UKCA marking, and so on. I will touch on that, and how standards relate to that. But of course, just to set the scene first, of course, standards that I'm talking about are not regulations. They're good practice agreements made by stakeholders that come together in multi-stakeholder processes where we work together, different countries working together in a technical cooperation based on consensus of all interested parties, whether they're businesses, large and small businesses, consumers, environmental groups, academia, testing houses, and so on. And these are processes that we run independent of any specific interest, as Ignacio said earlier, talking about how TCA addresses the definition of international standard, but doesn't address memberships in regional standards organizations. So this is a technical cooperation that I'm talking about. It does link into regulation. I'll explain how that works. But I'm going to just to talk about how standards continue in the UK after EU exit, what that model looks like. Then more specifically about how that fits with the UKCA regulation, and Sam already mentioned designated standards, so I'll talk more about that. Then I'll talk about how BSI fits into the European framework of standards development, and will continue to do so as we move beyond, have moved beyond the EU exit transition period. So if I can make it move forward too quickly. So I'll start with a little bit of context. As I know many of you on the call are familiar with, having looked at the list of familiar names. Standards are developed in an international system. BSI is the UK's national standards body. You could replace BSI with any one of the 34 member countries of SEN here, because all of those form part of this international system. We work together with our fellow standards bodies around the world to develop international standards in ISO and IEC by sending national delegations to participate in that work. We work together within the European region to develop European standards within SEN, within SENLEC, within ETSI, and for SEN and SENLEC, those are linked very closely and aligned with the international standards from ISO and IEC. And that's all done again through sending delegations of experts from the UK and indeed from the other countries, where they discuss together how the standards, what the good practice looks like in the particular area, whether it's a specification, product, a process, testing method, whatever. Within the European system, I think things are a little bit different than internationally, because we go slightly further than the international system does. So what all of the members agree, the members of SEN and SENLEC agree, is that whenever they develop a European standard, they will adopt that identically as a national standard, and they will remove any conflicting national standards that already exist. So what that gives us is a coherent system of about 24,000 European standards that are identically adopted in all of these 34 countries. And of course, that supports minimized friction of trade across Europe. It also supports very closely the European single market and regulation there, as well as regulation in other countries here within the European membership. And so this is the broad picture of the international system. We work within that system. We will continue to work within that system, and so EU exit has not changed that. BSI does what it's done for many years, which is enable the voices of UK stakeholders to be heard in the development of standards, whether they're national standards, national only standards, which there are now a really small number, or whether they're European or international standards, which currently make up 85% of the UK national catalogue. So we do this through that international membership, through BSI sending representatives to ISO and IEC committees, to SEN and SENLEC committees, also to ETSI. And that means that we end up with a national collection of standards, some 40,000 British standards in the national collection, which is a coherent and non-conflicting collection of standards. So we don't develop a standard on one issue. If we already have one, we say, well, we have the international standard. This is the international good practice where the UK stakeholder voice has been heard. Therefore, we have that as the British standard. And that, of course, includes the 24,000 European standards from SEN and SENLEC that we've developed in conjunction with the other members of the 33 other countries. So we have this coherent collection of standards. We continue to do that. We continue to make sure that the UK voice is heard in developing those standards, and that's our role. At the same time, we of course enable regulatory conformity in the domestic market within the UK, where UK government wishes that to happen. So UK government may request the use of standards for specific regulations. I'll come on to how that works with the UK CA marking in a second. And we support that. We support that by bringing together UK stakeholders, reflecting an offer back to government of standards that comprises or comes from our membership of the international and European organisations where we take part. So that support of UK regulatory policy is one part of the work that we do. It's one part of the standards framework in which we're operating. To reflect that in more detail in relation to product regulation, Sam's talked in some detail about how this looks now, and I've just noted here that we have, of course, this division within the UK market for the CE marking, UK CA marking, between Great Britain, England, Scotland and Wales, and Northern Ireland, where Northern Ireland is continuing to follow EU regulations through UK adoption, whereas Great Britain follows an autonomous regulatory policy of UK government. So we have the harmonised European standards that are cited in the official journal. They enable conformity of regulations in Northern Ireland in exactly the same way as they do within the EU, in fact within the EEA. But within Great Britain, then the position is slightly different. Sam mentioned designated standards, and there's a new category of standards. They are designated by UK government for the purposes of conformity to regulations, UK CA marking regulations in Great Britain. Normally the use of that standard, where the standard is designated, the use of that standard brings a presumption of conformity to relevant requirements of the regulation in Great Britain as part of the UK CA regime. And so what that means is essentially the designated standard is the equivalent of a harmonised European standard that's cited in the official journal of the EU. In order to make that happen, UK government at the end of the year, so at the end of the EU exit transition period, designated all of the relevant harmonised European standards cited by the EU. So it's well over 3,000 standards, something 15% or so of all European standards were then designated by UK government, and they can be used with the UK CA marking to give a presumption conformity in a similar way to with CE marking. And that meant that the lists of designated standards on the 1st of January were identical to the lists of harmonised European standards cited in the OJ. Now that's of course a government act in the same way as it's the European Commission that cites standards in the official journal. It's UK government that designates standards for conformity with UK regulations in Great Britain. What we do in BSI is to help with that by informing government when new standards are coming through the SMEs process, such that then UK government can decide whether it will designate those standards or not. And that's what we're doing now. We've set up a process working with UK government through the business ministry, just so that we inform them every quarter of new standards that have got to a certain point in the SMEs development process. So at a point where those standards are coming for adoption as national standards, at that point we say this quarter there have been 50 or 60, however many standards have gone through the process and have got to this point at some time in that quarter, and therefore they are available for consideration for designation by government, and government makes the decision itself whether to designate the standards or not. So that's the essence of the process that we've created. We give that information. We did it in January, we did it in April, but we'll continue to do so because we have that information coming through the SMEs processes through the data feeds that we receive from them. In addition to that, BSI has now updated some of our online tools. So that's BSI Shop, British Standards Online, and Compliance Navigator. Updated those tools to show which standards are designated by UK government for regulatory purposes. In due course, we'll also be doing that to show which standards are cited in the OJ, so that there's a comparison between the two, and you can understand which of the standards that give you a particular legal advantage, presumption of conformity in Great Britain, which would do that for Northern Ireland, of course. But the important message, I think, here is that while the way in which government references standards have changed. Previously, it was a citation in the OJ. Now it's a designation by UK government. The technical content of those standards has not changed. So these are standards that are coming through the SMEs processes in the normal way, in which all 34 countries have had a say in their development. They've voted at the end positively. That technical content of the standards remains identical to what it was before. UK government is designating standards saying it's the EN standard, and so it's clear then that is the same version, whether it's a BS-EN or an EN adopted by Ireland or France or Germany or wherever. Moving on from that to SMEs membership, the statutes of SMEs, as they are currently written, they permit the members to be the national standards bodies of countries that are EU member states, that are EFTA member states, or that are on their way to one or the other of those. There's no possibility for a country that was a former EU member state to have a member of SMEs. This, because we saw this as an old definition that came when the idea of countries leaving the EU hadn't been considered. We wanted to look again at the statutes, because we've been speaking to our stakeholders, so UK business, UK consumers, academia, and so on, ever since the referendum back in 2016, to understand their preferences and their desires in terms of the UK's involvement in the development of European standards. And what we've seen consistently and throughout the time, without any significant opposition, indeed no one committee, no one sector, no one trade association has ever said that they would not like BSI to continue as a member of SMEs. What we've seen instead is absolute overwhelming support for continued membership and recognition of the importance of that pan-European technical work that's done in the development of standards. And so the BSI's position has been to continue as a member of SMEs. At the moment, we're continuing because we have a derogation from the statutes until the end of this year. Our voting rights have slightly changed. We've moved into the non-EEA category, but which means that no non-EEA countries can hold up technical harmonization that links through to single market issues if that is particularly wished for by the EEA members. But that aside, BSI continues as a full member until the end of this year, and during that time we're working with the other members to develop a new model of membership. And that new model of membership will look at technical parameters. It will look at participation in the governance of the organisations, and we will expect to see a proposal for what that will look like to be voted upon at the General Assemblies next month. So we expect to see that in the next few weeks. What we have argued for, or throughout, is that this, as a technical cooperation, requires members to have the same rights, even though they may not have the same voting rights in relation to EEA issues, in terms of acceptance of European standards. But the technical participation rights, we believe, should continue as they are now, and indeed we're hoping that that's the way in which the proposals as they come through from Senator Sunlight and discussed with the members, the way in which we hope that will play out. So it's something where we are moving towards the final decision-making time. Decisions to be taken first in June, and then we'll move through the rest of the year with discussions and confirmation of BSI's position as of January next year. We want to make sure, I believe, as all the members do, that those who use the standard system, the stakeholders who use the system, can be confident that it will continue to reflect their needs and their wishes in terms of pan-European standards development, the use of a common set of standards, and the understanding when necessary of any minor differences that arise here or there within one or other of the members, that can then be passed on as information to businesses throughout the membership as necessary. I think I only have one more slide, which is just to give some further information. I put in the list of designated standards. I know that Sam's given far more comprehensive information, but as I was referring to that, I put and the final link here is to the UK government website. Other than that, we have information on EU exit issues related to standards, but also specifically about standards questions in relation to their designation and how standards link to regulation within Great Britain and Northern Ireland. And we have a particular web link for that. And then our contact details if you have questions on standards related issues in this area. And having said that, Maitani, I'll hand back to you.
Thank you very much, Richard, for the presentation. I think it was quite useful, and we will have to see as well what happens at the end of this year regarding the new membership modalities that BSI will also have in SEN and SENELEC. So I don't see we have questions open. There was a question, but it has been answered in written by Sam. While people are still thinking about their questions, Sam, I had a question that we also received ahead of this workshop. which I don't know if you can maybe give some details on that one. It had to do actually with goods that might be a bit more complex, for example, industrial machinery, and that might also require, for example, installation by the manufacturer. So the question that we had received was that upon delivery of machinery to the UK, whether there is basically a clear guideline to follow as to when an exporter can use his own personnel visa-free for the installation. I don't know if you can give us an answer, or otherwise give us a hint of where the person could find the answer.
I think it might be the latter. So this is business travel. And it is something that the agreement doesn't cover in a lot of detail. So the answer will depend on which member state in particular the personnel is traveling from. So it's not necessarily one answer for every single member state for someone traveling to the UK. But there is guidance on gov.uk that will give you some explanations about how to travel to the UK for business, and that is exactly what this would be. It would be traveling to the UK to carry out a business.
Okay, thank you for that. So I think it will require some investigation for the person that has this question. We don't have questions, but actually I had a question as well. Maybe also the colleagues that are there from the European Commission can also give a bit more information on that. We know it was mentioned by Alban that there was a part of the agreement that is covering or that mentions SMEs as well. And in that part, it is mentioned a series of measures like trying to put available information like a portal where SMEs could find information. Does this portal exist already in both sides, in the UK and the EU? And also, are there, also this question is mainly more for the colleagues from the European Commission, what kind of support can SMEs find? I'm sure that at national level there is support available, but there are other kind of support, for example, regarding training, since there might be now more work with dealing with customs, also rules of origin. So is there any kind of support in that regard also coming from the EU level? So I don't know, Sam, if you can tell us more regarding the portal from the UK side, and then we can maybe pass to the colleagues from the Commission.
Yeah, of course, happy to. So in terms of a single portal with all of the guidance in one location, that obviously spans issues that are a little bit wider than the ones that we've been talking about this afternoon. And I'd have to kind of check in on that and any plans to have everything in one place. What I would say is that we are always aware that a lot of the stakeholders in manufacturing supply chains are SMEs, and we are very mindful of that when we are developing the information products that we have. So the slides that I shared with you this afternoon, we've worked with a lot of SMEs in the UK to develop and make as accessible as possible. And the same goes for the written guidance that we have online as well. We always try to make it as easy to follow as possible for an SME audience, because we are aware of how challenging that can be. On the specific question of whether we put all the guidance together into one place, that is not something I know the answer to right now, but happy to look into it.
Okay, if you have some feedback on that, I'm sure our audience will be, would appreciate that. So it would be great if you could pass us information on that. From the Commission side, I don't know if there is any comment on that.
Yes, Maitana, I will take the question. Let's see if I can get the video going.
We see you. So
okay,
yes.
Perfectly. Regarding for the UK, there is no specific portal that only covers UK and SMEs, but in the slideshow that Ignacio showed you, there were 3 different links. One of the links goes to DG Grow, which have a special SME portal, which covers a lot of information regarding SMEs and SMEs network and SME support. which will also cover the TCA, but there is no specific portal that only covers SMEs and the EU-UK TCA agreement. The same goes for the DigiTrade website, where we have this access to markets, which is a very useful website where you can find a lot of detailed information, in particular the new developed tool on ROSA, which is a rules of origin specific tool that will help all our operators to identify the specific requirements when it comes to documents and other necessary documents that you need to provide for requesting the origin of the goods. We also provided a link to DG Taxud, which has provided a particular website which covers both the withdrawal agreement and the TCA. So there are different sites from the different commission services, which is there to support SMEs and other business operators in general. But there is not like one single portal that encompasses all this information. When it comes to training, there is no specific training foreseen for this kind of activities, but I can only advise business to look closer to this information provided on the website, which contains a lot of information.
Okay, thank you very much for that. I see we actually got a question through the chat from Deborah Vautier. It says, what would happen if the UK government decides not to designate a standard, despite that it is a harmonized standard, and that Northern Ireland, would Northern Ireland have to apply it, and would such a standard give presumption of conformity in Northern Ireland and not in Great Britain? And then the link to that, she also ask a question, would an additional test of conformity be required between Northern Ireland and Great Britain? I don't know, maybe Richard and Sam, you can comment and answer this question.
Shall I start, Sam?
Yeah, sure. Let's see if we can do a two-hander.
Great. So, well, in terms of the standard, so obviously the European standard will be adopted as a British standard. That's how this normally works, and then government will decide whether it designates that standard for the regulation for Great Britain, and at the same time, the European Commission will be deciding whether it cites the standard in the official journal for the EU, which also would then be relevant for the market in Northern Ireland. So if if the European Commission cites the standard in the OJ, then that standard would give presumption of conformity to the UK regulations applying in Northern Ireland that implement the EU law. And so that in the same ways as prior to EU exit. So that means it would have a status in Northern Ireland. That doesn't mean necessarily it would have to be applied, because of course it would retain its voluntary characteristic as it's a standard rather than a regulation, unless there's something, construction products or something like that. So that's the first thing. So it would be relevant for use there. If UK government did not designate the standard in relation to the UK laws applying in Great Britain, then it would still be the British standard, but it would not provide presumption of conformity to whichever the regulation is in Great Britain. So you could have the situation, yes, where the standard is cited in the OJ and therefore would give presumption of conformity in Northern Ireland, but at the same time not designated by UK government and therefore not providing presumption of conformity within Great Britain. So yes, that's possible. Nevertheless, it would still be the British standard in cases, because in each case, because it's a standard would have been adopted by BSI as the UK's national standard.
Thank you, Richard. Yeah, completely agree with all of that description on the status that the standard would have. To answer the second part of your question, Deborah, I touched on this a little bit in the presentation, albeit briefly, but the UK government has made a commitment to businesses in Northern Ireland that products that are called qualifying Northern Ireland goods, so products that are already on sale in Northern Ireland, can have unfettered access to the market in Great Britain, except for a handful of cases where there are some kind of exceptional reasons to require some extra light touch information. So, for example, if you have a chemical product or a medicine in Northern Ireland and wish to benefit from these arrangements and place them on the market in Great Britain, then you need to supply the relevant regulators with the information so that they have the same information that the EU regulators that cover Northern Ireland have. In the case of a new approach product, however, which would be something more typical to be using a harmonized designated standard, those products would be able to be placed on the market in Great Britain, even in this situation, even in this hypothetical situation where the harmonized standards were different. And actually, because of the way unfettered access works, it would even be true in theory if the essential requirements were different. Although, to be clear, we haven't yet seen any examples of a case where the essential requirements between Great Britain and the UK and the European Union and Northern Ireland have differed, but the commitment to unfettered access is there to protect Northern Ireland's place in the United Kingdom.
Thank you for that clarification. I don't see any additional questions from anybody. So I think there is a lot of information as well to be digested after this workshop. And I would like to thank you all very much for your participation and for all the insights that you provided us in the workshop. I think what is clear is that, as I think Ignacio was saying at the beginning, we have an agreement which is a bit different in the sense that we were coming from convergence, and what we need to manage is possible divergence in the future. I think at the moment we all need to get used to these new rules that are applicable, and we also will have to see how this evolves in the future. So we hope cooperation between all parties continues, and that SMEs, of course, we can find the support and all the information we need in order to continue doing businesses. So thank you very much again. Just to remind you that you will receive the recording and as well the presentations in the SBS website. We will send you an email by the end of the week with the link. And just to let you know that when you go out of the webinar, you will also have a short questionnaire. So please take a couple of minutes just to let us know what you thought about the workshop. It's very important for us to know whether you found it useful and any suggestions you might have. So thank you very much and good afternoon to everybody. Bye.